Okay, we're recording. So whenever you're ready to get started, Cynthia, it is all you.
Okay, thanks so much. Hi, everybody. My name is Synthia Melton. I'm a partner at Dimension Law Group. And today, Gideon mentioned to me that the brokerage is starting property management services. So I figured today would be a good topic to talk about the crazy changes we've had to the Washington Landlord Tenant Act over the last 2 years. There's more changes coming, and it's not just statewide, it's on the local level as well. So we're focusing on the landlord tenant stuff today, but there's also an opportunity for you guys to ask questions that are relevant to you. I don't know if everyone that's online is going to be involved in property management, but if not, some of this information is still helpful to your sellers, your buyers. So let me go ahead and try to share my screen. Let me see.
Awesome. And Cynthia, most of the agents are just doing transactions, but most of them also own rental properties too.
Oh,
so
perfect.
For themselves,
Well,
it's useful.
As landlords, it's going to be, yes, if you're an investor, and I'm a landlord personally as well in Washington and out of state. So I care about this stuff just because it affects my business as well. So let me try and see if this will work. Give me 1 second. Okay, here we go. Can you see my PowerPoint?
We can, yes.
You can, okay. Well, for some reason, I cannot make it bigger. Weird.
Top left corner, maybe, from beginning.
Yeah, wait, oh. There we go, perfect. I tried that button last time, it didn't work. Okay, awesome. So we're just gonna get right into it. So, kind of just what we're gonna cover today. We're gonna cover some updates to some of the local ordinances. The reality is there are way too many that we just don't have the time today to do that. And it would take hours and probably days to go over everything. So we're gonna try to just go over where you guys can find the information, what you need to know. We'll chat about the statewide changes that happened last year. And then we'll talk about the eviction process. Hopefully, you guys it won't get to that point, but if it does, whether it's you as landlords or for your clients, there'll be some helpful information there. And then we'll just chat about best practices, especially if you are buying or selling properties where you're inheriting tenants. So kind of how to deal with those tenants. So let's just get right into it. And so this right here, this looks like a lot, and it is a lot. And so these are just a few of the local ordinances that were either introduced or considered and passed in 2019, and that's just in 2019. The next screen that I'm going to show you, we'll just jump to that screen really quickly and come back to this. So this next screen is a list of the major policies that are going to be introduced in 2020. And essentially what we're seeing and the trend we're seeing is that not only as landlords do you have the federal laws, discrimination, that type of laws, you've got your state level, which is what most people have known and have practiced, but now you've got each city having their own local ordinances that you as a small, mid-sized landlord have to follow. And a lot of it can be burdensome on people. So the landscape's really changed over the last couple of years, and this is an area where for us as real estate attorneys, it's continuing to change. I think, most of you know Washington is one of the most progressive states when it comes to landlord tenant laws. And the effect of that, unfortunately, is it's really burdensome on a lot of smaller landlords. So with the list of proposed changes, just looking at this, I can tell you, for example, Federal Way just passed an inspection program and an initiative for Just Cause. Most of you may know Seattle has had Just Cause for a very long time now. And when I say Just Cause, what I mean by that is essentially there are additional rules that you have to follow if you want to ever evict a tenant. And you have to follow not just the state laws, you have to follow these local ones. So we're seeing a trend now. Auburn has an inspection program. I know Lakewood does, City of Tukwila does. Burien just implemented some really tough things for smaller landlords. But for example, for you guys as agents, one of the things on here, you would need to know if you're selling multifamily for a client. So if you're listing a multifamily property, Seattle has what's called a notice of intent to sell. And what essentially that is that's an ordinance that requires owners of multifamily housing where if it's 2 or more units and at least 1 unit in that multifamily is considered an affordable unit. And there's, ways that they figure out what that is. And we're not going to go into that today, but you just need to know that if you're selling a multifamily and it's 2 or more units, there's a potential. So when I say 2 or more, that would be a duplex. There's a potential that you will have to provide the city notice. And for Seattle, I believe it's 90 days before it's listed for sale. Burien also implemented something similar, except theirs is for 5 or more units, and you have to provide the city notice 60 days before it's listed. And essentially, you're giving the cities an opportunity to make an offer to purchase. And so if you don't give them notice of your intent to sell, there's penalties. I believe the Seattle one is right around $2,000. So, these are important things that it adds an additional step to your job as an agent, or if you're a landlord, you need to know if I own multifamily and I'm trying to sell, or you also need to know something as simple as, am I required to have a business license in this city to have a rental property? I am going to say, if you guys have questions, since I'm not sure how many more people have joined because I'm not on that screen, but if you guys have questions, you can feel free to just interrupt me and we can kind of make it more interactive. But really, that's kind of, this isn't to scare you. This isn't, it's really just to educate you that one of the important things you need to do now is investigate at the local level. What are the additional requirements you have for your rental property? Burien, for example, if it's a multifamily property, you're required to have a business license. If you don't, the penalties are huge. I think they're $100 a day for up to a certain amount, and then they go up to $400 a day. So, these are the things.
I'm sorry, quick question. The business license is not too hard to get, right? It's just an online application.
Most cities, it is an online application, and there are very few cities that don't require it. So my general consensus is, you just want to check with the local city, but you should be able to apply for it online. Now, the caveat is, if you were required to have a business license and you've been operating your rental, and then you go to apply and you don't have one, there are some penalties that could be put in place. So it's kind of like up to you as to what you put as your start date. I'll just leave it at that. But a lot of them, yes, it's online and you should be able to just do that and get it. The rental inspection programs, though, a lot of cities have that, and a lot of people don't know that, where your property has to be registered. Each city, the reason this is burdensome and it's hard, because even as attorneys, we don't have all this memorized. I mean, it's changing. The landscape is changing so fast that, we're trying to keep up, but I don't have these ordinances memorized. I have to look it up. So when I have a client that comes to me and says, hey, I need to do an eviction here, or I have to, I'm starting a rental in this city, we need to research not only at the state level, but the local level, and see if they've met all their requirements. Because if it ever came to a point where we then had to evict a tenant for non-payment of rent or anything like that, and for example, they don't have a business license, then that's a defense to the eviction from the tenant. So that's why it's important to know what your city's requiring, and if it's registration, you're registered, and keeping up with that. So that's just the caveat with this. There's a lot, and it can be overwhelming, but if you know where to find the information, it at least gives you a chance to prepare and you know, and make sure you comply. So let's kind of go into, so this is some of the stuff that's coming in 2020.
Hey, Cynthia, I had a question about the last slide. And also wanted to give whoever asked the last question just a moment to, if they had any follow-up to that question.
Yeah, for sure.
Mine was about the multifamily sale. Since most of our agents are transaction focused, we're going to see some sales. So can you go over that bit again about they're going to have, like in what situation do they have to offer the city the right of first refusal?
The notice,
And where
yeah.
is this?
Okay, so let's go over. So right now, the only two cities I know of that have this in place is the city of Seattle. And so if the property, you want to make sure, you know, it's within Seattle city limits, look it up on Parcel Viewer. If it's, sometimes it has a Seattle address and it's, you know, unincorporated King County, then you wouldn't have to. But if it's in Seattle city limits or if it's in Burien city limits. So, and this is, you know, just generally, Seattle requires that if you are, as a seller, you are intending to sell a property that includes, that has 2 or more units, and if at least one of the units in that building is considered, it has an affordable housing income. So it's usually 80% or less of the area median income. So they have a, and I can send out a link, but excuse me, Seattle has a page that lists out the details of this as to how you would determine if they would fall into this affordable unit. But yeah, if it's 2 or more units and one of those units are an affordable unit, then 90 days prior to, so it's 90 days or before you list the property, you have to submit a declaration to the city of Seattle that, you know, the owner has complied with the notice requirements. You have to, essentially, you have to let them know that you're selling, and you have to post a notice in all the common spaces of the building that's visible to the tenants, and states that the owner
Is that like more than the front door?
Yeah, so well, visible common spaces, so it would depend really on what the building looked like, right? So if there's a on-site laundry or something like that, but it would be more that if there's a bulletin board or something, so you might have to place it in a couple of places. So all it says is just common spaces that are shared, and making it clearly visible to let the tenants know that the owner intends to sell. And then if the owner receives an offer to purchase the building before listing, and this is, I just pulled this up, or if they're advertising it for sale and they accept the offer, the owner has to provide the notice and a declaration within 2 days of receiving the offer. You have to submit that to the city. So essentially you're giving the city an opportunity, you know, to have right of first refusal. If you don't follow the notice provisions, then the penalty is $2,000. But that doesn't mean, you know, it hasn't actually, these things they're new, right? So we don't necessarily know how they're going to play out. So we don't know if it's a one-time fee of just $2,000, which to some people financially, it may make sense to say, hey, I'm not going to give the city notice. But then what I think, the way I'm reading into it, is that you have the penalty and then you still have to follow the 90-day rule of giving them notice. So it's really important. So that's for Seattle. There's a lot more information on their website because some of this stuff is still new. So it's not 100% clear. They're still seeing how it plays out in practice. And then for Burien has, you also have to notify the city in Burien, but if it's 5 or more units. So if it's 5 or more units, and if at least one of the units there is considered affordable housing, it's an affordable unit. And then Burien's is 60 days prior to listing. So we just had a situation, I was speaking at a CLE and the attorney told me his client, they listed the property, they had to take it down because they didn't comply with the notice. And so they had to submit the notice and wait the 60 days and then relist.
Gotcha. And the city has the right to, like, a right of first refusal where they can buy it for the same terms, or is it just a notice?
Well, it's giving them an opportunity to try to match, you know, whatever offer, for them an opportunity to buy it as affordable housing. Essentially, that's what they're trying to do. So you can provide the notice. They may not want it, but like Seattle, for example, requires that if you get an offer to purchase the building, you know, then they have to notify the city within 2 days of receiving the offer.
And do they have to take the city's offer? Like, is it like eminent domain, or is it?
No, it's
like
not. No, it's not like eminent domain. I mean, you would still have the opportunity to negotiate.
So they're still competing
gotcha.
with the offer, right?
I'm sorry?
So they're still competing with their city is as just a buyer, another buyer, and they're competing with the offer. It's not like they're not like the first right to refusal, right? They don't have a right over it. It's not like, hey, we got an offer of $1 million, city, would you like to match it? It's not like that.
Right. It's not necessarily, it's just putting them on notice. So if they want to come in and say, hey, here are the terms.
Got it.
You know, yeah, exactly. So it's
Is
just
it
another buyer, basically, right?
I mean, can you play, like, after the city submits their offer, can you basically play that to the other buyer to increase theirs? Like, are there any restrictions on the negotiation?
I don't see why you couldn't. I don't know the impacts of that. Like I said, it's still fairly new, so I don't know how that has played out yet. I haven't had a client that's had to do this. So I don't know in practice how that would work.
Okay.
Yeah. So, all right. So that's the notice to intent to sell. But, you know, as you guys
Stops for like maybe 30, 60 seconds. Can you just give that really epic intro again?
on Washington.
Or at least like a summary of it?
Yeah,
or I
yeah.
guess read the first line.
I was just saying basically for, you know, the Washington Landlord Tenant Act, we had major changes last July that went into effect. And we have not had changes at the statewide level. You know, there's been minor things here and there, like security deposits went from 14 days to returning it to 21 days. So minor things, but this was massive changes last year, and we haven't had changes like this in 46 years. So they really did a big overhaul to a lot of the sections to kind of protect tenants more. So really that's what, you know, there's been substantial changes, and we as attorneys have gotten really used to the old stuff. So now it's really changing our forms, learning this new stuff. And you can see with a lot of landlords that are trying to do notices and evictions themselves, and even a lot of property managers. We just had a case come across our desk yesterday where in December they still used a 3-day pay or vacate. Well, that means their case is dismissed. It's not going to work. If your notice, the most important thing in the Landlord Tenant Act, and if you wanted to evict a tenant for any reason, is that your notice has to be proper. If your notice is not proper, then your entire case is getting thrown out. So one of the biggest changes was to the pay, rent, or vacate. So it used to be that you as a landlord could give a 3-day notice, pay or vacate. You used to be able to include late fees on there. Utilities have always been on a separate 10-day. But now with the new law, you have to give a tenant 14 days, so almost half a month, to pay rent or vacate. and it can only include rent. They included a new definition of rent. So rent is basically going to be what your base rent is plus any recurring charges. So they did include utilities specifically. So if every month they have to pay utilities, if they've got monthly parking charges, you cannot have, if you've got late fees, you cannot add it. It will invalidate your notice. Any, one-time fees that you may have. So a bounce check fee or anything like that cannot be included in the 14-day notice. One of the caveats is, so let's say you give a tenant an opportunity to pay their security deposit over several months. If it's still a reoccurring payment, that is a one caveat. That is something that you could include in there. But really, it's just rent plus any reoccurring charges. So you cannot get late fees anymore. Those will have to be on a 10-day notice to comply or vacate. But the one important thing to note about that is if you give a tenant a 10-day notice to comply or vacate based on non-rent amounts, what I mean by that is, so you give them based on late fees or whatever other charges are allowed in your lease. So bounce check fee, for an example, you can't evict them on that. You would have to go separately. You would have to go to small claims court. So you're sort of limited in what you can evict on now. Even though you cannot include late fees in the 14-day notice, if we go to court in an eviction, we are limited. We can get you some of the late fees, but it's limited to $75 in the eviction judgment. The rest you have to get through small claims court or other civil suits. So, the important thing with this is you don't want to let a tenant continue their default or their non-payment for a long time, because you're not going to be able to collect those late fees. So that's really one of the most important changes. The other thing too is when you're applying rent payments, it used to be that when a tenant would pay, you could apply it to their fees and all the defaults aside from rent first. Now, any payment they make has to be applied to rent first, and then the rest can go to the remainder. There is forms for those of you that are landlords and that are going to be issuing notices either on your behalf or on your client's behalf as property manager. The Washington State Attorney General's office has forms available on their website. They have them in the 10 most common languages spoken in Washington, because one of the other requirements is that if you know that your tenant is fluent, doesn't speak English great, has another language that they prefer, then it's not a requirement, but it's good practice to give them that notice in their language. So does anyone have questions about the pay or vacate, or does everyone already kind of know about the changes? Okay, so let's go on to the notice of rent increase. So this is another one. It used to be the old law that if you wanted to increase your tenant's rent and they were a month-to-month tenant, you would give them a 30-day notice. And it's not 30 days, so what's today? Today's the 8th. So it's not that I give you, my tenant, a notice to increase your rent today on the 8th, and then on February 8th it goes into effect. It's 30 days or more before the end of the rental period. So if I give, the old law was if you give your tenant notice on, let's say, January 8th to increase their rent, it doesn't take effect until March 1st, because it has to be 30 days or more before the end of the month. So the old law was 30 days on a month-to-month tenant. The one part that stayed the same is if your tenant is on a term lease agreement, meaning they still have time, they're on a 1-year term or on a 6-month term, you can't change any of the terms until that lease has expired, unless, of course, both of you mutually agree. Then you can change the terms. The new law, statewide now, all rent increases needs to be 60 days for month to month. So that's for every city. That, Tacoma already has 60 days. So this is, the state law is similar to that. So you want to make sure it's 60 days or more before the end of a monthly rental period. So Now, if I were to give my tenant a notice of rent increase, it's January 8th, their rent does not go up until April 1st because it has to be 60 days or more. And that's just, the only time you can do that anyways is if they're in a month-to-month lease. I will give a caveat about month-to-month leases. I don't like and I don't recommend people do month-to-month leases in Seattle. And the reason for that is because they have their just cause ordinance where you cannot terminate a month-to-month lease unless you have one of those 22, you have to meet one of the 22 criteria in their just cause ordinance. And yes, of course, one of them is non-payment of rent. But if you wanted to terminate a tenancy, it becomes a lot difficult. So what I recommend in Seattle is doing, if it's a tenant you're not sure about, do short-term fixed leases. So 3 months, 6 months. That's a much better way to go about it than doing month to month.
So in Seattle, I'm under the impression that you have to pick the first tenant. So can you elaborate on that last point about if you're hesitant about a tenant, you mean after the lease is over, or is this before you even pick a tenant?
So, well, before you pick a tenant, you do have to, Seattle did, the Supreme Court last year came back and basically upheld the Seattle First in Time law. And what that means is that the first tenant, that is, the first one that is screened and meets your criteria, you have to accept them. So this is the important part about this, is making sure you have a solid criteria. You want to have it so whether you're listing on, I don't even know where people list for potential tenants, Zillow, Craigslist, whatever platform you're using, you need to make sure you have a solid rental screening criteria and let the tenant know what all you're screening for. So what your minimum credit score is.
A quick question on this, if you don't mind. So let's just say, yes, the solid criteria, we set it up, it's made it public, so it's even for everybody.
Yep.
How about, is there a possibility for us to say, just like a multiple offer situation, seller might accept the offer before the open house or before this date, right? So how about set up a higher criteria and the same configuration, property manager or the landlord might accept the offer, or might consider anything below this, but it's case-to-case basis. Is that legal?
No, it's not. So essentially, if I understand you correctly, I would say no. So essentially what you want to do is, and I don't know if you guys are members of the Rental Housing Association, I sit on the board. I don't get anything for telling you this. I use their leases personally for my personal properties. But I know who writes their leases, the attorney, and they're vetted, and they actually offer a free criteria that you can use and post for members. They give you an example, because what the goal is you want it to be similar for everyone, right? So you don't want to say, you don't want to have any sort of loopholes or make it seem like it's different for one person or different for the other. So what people have started doing, at least I can tell you with members of RHA, is now, because of First in Time, they have really stringent criteria. I mean, they have strict criteria. You need to make X amount more than, the monthly rent. You need to, and they will only accept, so whoever submits an application first, if that person meets all the requirements, then you have to accept them, even though, let's say you held an open house, right? And you've got applications and a bunch of people come and take applications, and one of them was just really rude to you, and just a really rude tenant, and showed up late, whatever the issue is. So you can't not, and if they submitted their application first and they meet all your criteria, you can't not accept them, just because they've taken that power away from the landlord to really assess, how would this relationship work with the tenant? So yeah, the short answer to that is I do think it's illegal. And I think that what's really important as landlords is that you have a solid criteria built and you just refer back to it. So if you're denying somebody, you can say, hey, look, I have this as a criteria in my and my screening requirements and you didn't meet that, and that's why I'm denying you. But the first in time is, it initially went into effect January 1st, 2017, and then we were able to win, RHA was able to win a lawsuit that basically made it go away, and now it's back. So that's something to keep in mind. And Gideon, I'm sorry, going back to your question, can you remind me again? So you said your understanding is that, you know, in Seattle, yes, you do have to take the first person, but you had a second part to that question.
Yeah, on the, you had mentioned just something about if you're feeling iffy about a tenant, make sure you do, you know, X. So was that like once you're already month to month, like in the full lease says?
So a lot of times, yep. So a lot of times people's leases will automatically go to month. I know the RJ leases, for example, it says, hey, when the term's over, you're automatically month to month. And then if you're month to month, you know, you have a harder time changing the terms. So what I recommend is you don't check that box. You have that it's over after the term, and you can select the term. So there's nothing stopping you from doing a very short term and then entering into a new lease agreement. Is it more administrative headache for you? Yes, it is. But, you know, that's one way to sort of try to work with a tenant that might be a little difficult, is to offer shorter terms.
Gotcha. I wanted to build off the other question also, because I thought it was pretty interesting. Is there some sort of way, just hypothetically, to have two criterias and like two rent amounts, or you know, is there any flexibility in it? Or is it like it has to be just one criteria, just one amount of rent?
Just one. If a potential, and this is what we started seeing when first in time was in effect, you know, people who were denied and didn't like the fact they were being denied, they're going to file a complaint against you, against the city. And then you've got to deal with the city, and it could potentially go to a hearing before the city. It's like, it can be a huge expense and time and headache, all because someone's pissed that, you know, they didn't get the place. So you don't want to open up any possible reasons for someone saying, well, no, they discriminated against me based on that. That's why the criteria is really important, having a good screening criteria.
Gotcha. And I know this question is a bit of a stretch, but hypothetically, could you have it with the criteria, but then decide to do like a lease option? I mean, more broadly, like if you don't like the tenants who apply, can you just decide to sell it even after they've applied?
So you can sell it. So even after the tenant moves in?
Or no, that after they apply.
Oh, after they
if you decide you don't want a tenant.
Oh,
or, you know, if you find there's an opportunity to sell it instead, because you end up getting a tenant, but like maybe you don't like it, so you're like, you know what, I don't think it's worth it.
This is before the tenant moves.
Is that lease basically? Yeah, but because the lease isn't signed, but they apply. Like, can you just refund them or something,
or
and cancel it?
Or just like unlisted, or just unlisted and listed back up again, probably like 2 weeks later, something like that.
Right. So, I mean, assuming it's not like a multifamily, assuming you don't have to give the city notice or anything, maybe. My answer is maybe. There's different factors that go into there, but you could. I'm trying to think. I don't really see why you couldn't tell a tenant, hey, you know, I'm deciding to sell this. I'm no longer going to be a landlord. You guys haven't signed a lease agreement at that point. So I think you could. If you are selling a property, though, that has a current tenant in it, you want to terminate that tenancy, Seattle, I believe, off the top of my head, requires 90 days to terminate. So you have to give them a 90-day notice. And that is only for a single family home. I'll tell you guys this, for Seattle, because of the way their ordinance is written, there is no way to terminate a tenancy for a tenant because you want to sell that is in a condo. Their ordinance, it's a big gaping hole. We've gone back and forth with the city on this. It does not address it. And so essentially you are not able to terminate to get a tenant out of a condo before you want to sell. Whoever the new owner is going to have to buy it with the tenant, or you're going to have to find one of the other reasons, non-payment of rent or whatever, depending on what type of lease they have, to get them out. But Generally, you're able to give a tenant 90 days to leave and then, you know, saying, hey, I'm going to sell the property, or your option is you just sell the property and the new owner inherits the tenant. But that's the condo thing is a weird issue we've come across several times with our clients, and there's just, Seattle will just say, nope, sorry, can't do it. So that's something to keep in mind. Okay, so I know what time, oh, 12:40, okay.
Yeah, we're running a little, but I feel like the last question, just the other part of it wasn't, can we get back to the last one just real quick? And the second question on it was, can you cancel the rental advertisement and then advertise it? So like, for instance, maybe you're thinking that you say like, oh, the owner would decide they want to do this little maintenance or change, and they think that that'll make the property more appealing, and they want to like cancel this and then relist it basically at a higher price later.
Yeah, I think that, and somebody's already applied, I think that would open you up to a discrimination claim against the city, or potential. I think that is tricky. A lot of these, you know, situations that we're talking about, it's hard to say because it depends on the very specific situation, right? So depending on the reasons for doing that, you may be able to have some sort of valid answer, but the reality is you may have to go back to the first person that applied and was qualified, and say, hey, you know, now we've increased the rental amount to this. So I think you would still have a duty to do that. Even if you took it down and relisted, gotcha. I think that first person who—
But you could increase the price at least?
As long as you haven't signed anything with them at that price, you know, no kind of holding deposit, paperwork or anything like that that lists the rent amount, I would say you might be able to. It's hard to give very
the right of first refusal.
I'm sorry?
Basically just give them like a right of first refusal on it.
Yeah, it's basically, especially if it's someone that you've already qualified and that's, you know, that applied and you already ran their screening and everything was fine. Gotcha. But I do think that could potentially do it. And here's the thing, guys, like a lot of this comes down to who the potential tenants are you're dealing with, right? There might be people that just don't care and move on to the next apartment or unit or whatever. But there's others that if they really want the place, then they might try to make your life harder and file a claim against the city. So it's going to come down to a lot of different factors. I always try to encourage people just working things out themselves, and sometimes you obviously can't do that. But a lot of it is going to be the type of individual you're dealing with and really the specific set of facts.
Okay, thank you.
All right, so
we are running near the end. This is great content, so yeah, I think it'd be great to continue through your slides.
Okay.
But I did want to give just a moment. Does anybody have any like totally unrelated questions that they wanted to get in? Well, that's convenient.
Does your office provide any standard lease which we will be able to use it, or something is like has to be custom made?
So I actually don't even draft lease agreements. I tell people it's cheaper for people to get them from RHA than it is for me to spend the time to draft them. So yeah, we don't do lease agreements. But I would highly recommend, I mean, there's, you guys have like your MLS leases, which I have to be honest, not a huge fan of. But I highly recommend the RHA ones. Don't just go online and these, especially with all the changes that have happened. So, so the other one thing we'll just focus on, statewide, for a month-to-month tenancy, statewide, you can still terminate using a 20-day notice, but you need to know, so if you've got a client that wants to list the property and they've got a tenant out because they want to remodel it, there are different requirements now. Now you have to give 120-day notice to terminate a month-to-month tenancy if you're doing any substantial rehab, change of use. Change of use can be something as simple as, the property had a Section 8 tenant in it, and now you're going to fix it up and you're not going to have a Section 8 tenant. So you are required to give 120-day notice. So that's something to keep in mind. Otherwise, you can still give the 20-day notice if the city allows it. For example, Tacoma doesn't allow it. So otherwise, it's 20 days or more before the month ends. And this is something that people get wrong a lot, is they'll try to give notice, just saying, oh, well, I gave them notice on January 1st, so their tenancy is over January 20th. No, they always get till the end of the month. You just have to give it to them 20 days before the month ends. And some of this we can cover really quickly, but basically a tenant now, so even if we go all the way to court, you've got a tenant didn't pay you rent, we get them out, they now have much more leeway to reinstate their tenancy, whether they were a month-to-month tenant or a term lease tenant. And this only applies if you're evicting them for non-payment of rent, which I'll tell you, that's the most common way to evict a tenant. All the other stuff is really hard to do and get set for trial. So a tenant is able to reinstate by basically paying you, the landlord, or the court, the judgments. So that means the past due rent, the court costs, and if attorney's fees were ordered, then they also have to pay that, and it automatically reinstates their tenancy. So this is a new thing that people need to keep in mind. So if you've got a horrible, terrible tenant that's not paying rent, and there's a lot of organizations that will provide subsidies basically, or help for tenants, so they're able to come up with this payment. But what we're seeing now is even after somebody reinstates, a couple months later they default again. So there is something in the law to try to avoid that. If you have to give a tenant 3 or more pay or vacate notices within a 12-month period, it's actually technically 4 or more, because it's you give them this final notice, but if in the preceding year you gave them 3 or more, then you can evict them. They don't have a right to reinstate. Money judgments now, landlords used to be able to get all their attorney's fees in court. Now, if a tenant fails to appear in court or defaults on the lawsuit that they receive, you as a landlord cannot get your money judgment. And also, there has to be, if your rent amount is lower than 2 months of rent or $1,200, you can't get a money judgment. You can't get your attorney's fees back. And the reality is, a lot of times when you get judgments from a tenant anyways, you've got 10 years to collect it. Most likely you won't be able to collect it unless, they've got their financial circumstances are decent. I will tell you, what we're seeing a lot of is we have people that we've evicted in the past that now are going to buy a house. And they're now coming to us for payoff statements because they can't buy a house without paying off their judgments. So you may get money later if they want to go buy a house. I know, Gideon, I know you said you have, you're going to share this PowerPoint, so I won't really go over this, but if you guys as landlords or as property managers are serving notice, this basically goes over how you have to do it properly. And as I mentioned, the notice is the first step. When you have a default, you need to make sure the notice is done properly. Otherwise, you can't continue to get that tenant out. And you guys can chime in. Have any of you guys had to go through an eviction?
Yes.
Yes. Okay. Was it for a tenant?
Yeah. As opposed, are there other evictions?
There's post foreclosure evictions for previous owners. We've got evictions when buying a property just on MLS and the owner refuses to move. There's lots of different types of evictions. So I was curious about. The process is generally the same. You've got to have some type of notice. Then once that notice period expires, you serve them with a lawsuit. And then you either try to resolve it out of court, or you go to court and then it goes to the sheriff. But it generally takes about 6 weeks. Sometimes it can take less, sometimes it can take more. So like I said, I encourage a lot of out-of-court agreements. So for example, if you're buying, property from auction.com or a trustee's sale or anything like that, a lot of my clients in those instances will do cash for keys. We also have a lot of people that will buy on wholesale because we deal with a lot of investors, and got some really messy wholesale deals. So I know for you guys, transactions, this stuff doesn't really apply, but if you're investors personally and you're thinking about those types of deals, then this is where this would be helpful. So just kind of some best practices. I don't know how many of you are buying or selling property that includes, tenants that are being, that are going to stay in the property. But really something you could do to help your sellers or your buyers is really doing your due diligence, finding out as much information, gathering the paperwork, getting ledgers. A lot of people don't have ledgers, but really you want to make sure that, security deposit is transferred over. If you've got a seller, for example, that wants to terminate a tenancy, we've kind of talked about how you do that because they want to be able to fix up the place and make it all nice and pretty before they list it. Knowing the city laws, that's kind of going to be one of the most important things I think going forward in this next year, is that we're seeing more and more changes, and a lot of these, they just will pop up, and the average person, unless you're keeping up with these changes, you won't know about them. So a good way that I myself like to stay up to date is, for me, it's RHA. For you guys, I'm sure there's other avenues, but you can sign up for the blog or whatever. Give us a call if you have any questions. We're happy to help. We do more than just real estate. We do business, and we also do estate planning and probate. So if you guys have questions that we can help with, we're happy. So we're happy to do that. So if you have any final questions for me, guys, I'm happy to answer them. I think we've got about 7 minutes.
Yeah, thank you so much. Yeah, if you have any final questions, jump in. Synthia is great. We just hired her ourselves for Pellego to work on our property management agreement. And so we can personally recommend her from our experience. We've got her changes back. They were awesome. And we're going to be asking some more questions about it. Yeah, and we're also going to be joining the RHA. So I'll follow up with everybody about that, see to the extent that we can just use those forms statewide with one, like a business membership. So
and they are
thank you so much for.
We also have city ones too, so that's great. Good for you guys.
Oh, perfect. Even better. Awesome. Any final questions for Synthia?
Yeah, this is Derek. Got a quick question, just a general question.
Yeah.
In the Seattle area, in your opinion, professional opinion, what are like the 3 most landlord-friendly jurisdictions out of the more larger cities like Seattle, Renton, stuff like that?
So specifically, I'm sorry, in the neighborhoods in city of Seattle, or just in Western Washington?
No. Jurisdictions like cities, like Bellevue, Seattle, Renton. What are some of the more landlord-friendly for renting? Or is that kind of too broad of a question?
None. No, I'm kidding. It's, that's hard to say. Some of the East Side cities and things like that, I think Bellevue, Redmond, Kirkland, we haven't seen as much coming out of that, the East Side, although next year I think Linwood's going to do something. But really, a lot of this, King County is about to put something in place. So it's going to be most of King County. So it's tough. I would say there's not very many. I mean, you have the east side of the state, but in terms of here locally, there's not very many. Bellingham is just as bad as Seattle. So now I'm talking more just, Western Washington. I know it kind of goes past your question, but that's because I can't think of really any.
Okay, fair enough. Thanks.
Yeah. I would say maybe Tukwila, where I am, we've got a rental inspection, but yeah.
How's Kitsap County?
There is, it's not bad. It's not too bad. It's not as bad as the rest, I'll say that.
Okay. Great, thank you.
You're welcome.
Eric, the follow-up question on that, or anybody else have any questions?
No, thank you, Synthia.
You're welcome, guys. Have a great rest of your day. And, you know, my contact information is up here. And if you ever just have questions, I'm happy to answer them. We deal with a lot of just like real estate, Form 17 issues, things like that too. So, or if you just want to chat, feel free to give me a call up, and we'll try to, you know, help you and do what we can. So thanks so much, Gideon. And yeah, like I said, feel free to email or call.
All right. Thank you so much, Cynthia. We'll share this out with everyone.